Today's video shares a current scenario that was described to me recently, and that scenario ended with this question: does missing the contract date kill the contract? The scenario: it is a seller finance transaction, so there's no lender approval issues. But the buyer had to ask for an extension because he needed more time to gather his down payment funds. This extension was granted and an amendment was signed. Then the day before the amended closing date, the title company called to say that the closing would be delayed one more day because the partial release of lien that the title company needed would not be ready until the day after closing. When the buyer was told that the extended closing would be delayed one more day, the buyer said he was too busy to close on that date and now could not close for another month. The seller refused to extend for an additional month. No termination of contract has been set up to this point, but the listing agent has put the listing back as active. The question from the buyer's agent: is my buyer out of contract? A couple of weeks ago, I did a video on the words "time is of the essence" and their impact in a contract. The words "time is of the essence" is not part of the closing date paragraph, which, as discussed in the previous video, when time is of the essence is not part of a paragraph, there is some flexibility as to date of performance. The parties can impliedly extend a closing date and often do. Sometimes the parties imply an agreement to extend closing by their actions, and sometimes the parties imply by their inaction. In this scenario, seller refused to sign an amendment to extend the closing. However, seller did not send to buyer any notice of termination. In this case, the parties are not necessarily out of contract. In my opinion, the seller should set a date for a closing in a letter to the buyer, a date that is reasonable for the buyer to meet, and then state that for the purposes of that letter, the time is of the essence. If buyer doesn't close on that date, the contract terminates, using the words "time is of the essence." Seller definitely needs to execute a second contract as a backup contract until that first is released. The other underlying issue in this particular scenario is whether buyer is in default for failing to close when the title company was ready, or at least within a reasonable time thereafter. My answer is no. The buyer wasn't in default because the one-day delay was the seller delay and not a buyer delay. The seller could not perform on the date of closing. After that date, the parties are free to negotiate another contract or terminate the contract. In this circumstance, neither renegotiation of the closing date nor termination of the original contract has been done. It is in the best interest of the seller and the buyer to mutually resolve this matter in writing as soon as possible. Thank you for your support. Allegiance Title is your trusted resource for results.